We're going to argue our last case, have arguments in our last case in Ray K.J.B. And I know both counsel is here, and we are prepared to hear your arguments, and the appellant may have 15 minutes, and the appellee may have 15 minutes as well, but you as the appellant may reserve 5 minutes.
Thank you very much.
Just please let me know.
May it please the court, I'm not going to reserve any time, and I don't expect to be standing up here more than 2 minutes.
We've heard that many times before. You take the 15 minutes if you need.
Ready? Go. I want to address one issue and one issue only. Everything else is addressed, I think, very well in the briefs on both sides, to be very fair to both sides. There's a non-proton problem here, okay? And that's the only real issue that I want to address today. And with all due respect to counsel, I did not know of the second non-proton order that apparently came out. If you look at my brief, obviously, and I've scoured the record. In fact, last night, again, I scoured the record looking to see if that entry ever made it here. We take the position that since that entry is not here, that it does not exist and it cannot be reviewed, which means that this court is left with the language in the entry which kept the following quoted. Permanent custody is not the only means to provide care with a legally secure permanent placement.
And I screwed up, because I can tell you, please don't use...
Oh, I apologize.
That's okay, we'll edit it out, but please don't do it again.
Thank you. I apologize.
No, I should remind you.
I know I should have known that. I apologize. But that is the language that is in the original order of the court. The original order of the court was what was appealed. That is the language that is included in the first non-proton order. That apparently is not the language in the second non-proton order, which is not a part of this record, as it did not make it from that court to here. It's my understanding from talking to counsel that she was able to locate it in the docket sheets, I believe. Is that correct? Thank you, Jackie. In the docket sheets, but for whatever reason it did not make it. I don't believe this court can review it on that basis, and I think the law is very clear that on that basis this court must remand the case, it must reverse and must remand the case.
Counsel, whatever's left of your 2 minutes, taking what you just said as true,
Right.
if that's the case, your opposing counsel made an alternative argument as to that issue. Do you want to address that at all? That even if we look at the non-proton, the one that you were talking about in your brief, and applying that language, the Supreme Court would not require a reversal based upon your argument.
I believe, Your Honor, looking at their arguments, I believe it has to be reversed because the court has made this finding, assuming that this is the final finding of the court at this point. That's where we're standing. If the non-proton order changes, obviously, then I would stand on the balance of my brief and the arguments made therein. Thank you.
Thank you.
Thank you, Your Honor. May it please the court, good afternoon. It is afternoon now, and I'm Jacqueline Corrigan, representing the appellee, the Summit County Children's Services Board. And on behalf of CSB, I ask this court to affirm the juvenile court's decision in this case. I, however, am not necessarily going to focus exclusively on assignment of error 1, which, as counsel said, was that the juvenile court did not make a finding that permanent custody was the only means to provide the child in this case a legally secure permanent placement. For 2 reasons I made that argument. First of all, as counsel noted, yes, there was indeed a second non-proton order that the juvenile court issued prior to mother filing her appeal in this case. Granted, that order does show up in the case appearance docket, in this case that was filed with this court. That case appearance docket was reproduced at docket number 157. The order's language was actually reproduced in that case appearance docket at the bottom of page 157A. The order itself, though, agreed was not included in the transcript of the docket that the clerk transmitted to this Court of Appeals. However, I would note that Children's Services did file a motion on July 7th with this court to supplement the record on appeal with the actual copy of that non-pro-tunc order. That motion is still pending, but CSB respectfully asks this court to grant that motion, to include that order in the record on this appeal, and to take notice of it. Alternatively, as Judge Callahan mentioned, there is the argument by CSB that we have not only an Ohio Supreme Court case, which is In re Schaefer, but also this court's decision in re NC from 2016, that both cases say that it's not necessary for a juvenile court to find that permanent custody is the only option. That's just one of the factors that the juvenile court has to consider. And so it's not necessarily a duty on the part of the juvenile court to find that that is the only option. Because again, none of the factors in 2151 414D is individually dispositive or is to even be weighed more heavily than the others. And the statute does not make the availability of a placement that would require a termination of parental rights an all-controlling factor. So even in the absence of the nunc-pro-tunc entry, the second nunc-pro-tunc entry, this court is not required to overturn the decision of the juvenile court and remand it. This court can affirm it. But additionally, I would like to just touch very briefly on Mother's assignment of error number 2. And CSB's position is that the juvenile court did not abuse its discretion when it granted permanent custody to the county. And that's because in order to make that point and to ask this court to reverse and remand this case, Mother has to show basically two things. First, she has to show that there's an abuse of discretion. And that's a well-established definition. This court cannot just substitute its judgment for that of the trial court. It has to find, before it would reverse such a decision, that the decision is unreasonable, arbitrary, or unconscionable. And this court has said many times in permanent custody cases that every reasonable presumption must be made in favor of the trial court's judgment and its findings of fact. But the second thing that Mother would have to show this court is that the juvenile court's decision, of course, is against the manifest weight of the evidence, and that therefore, after reweighing all of the evidence in the case and all the reasonable inferences that came from the evidence that was presented to the trial court, this court would have to find that the juvenile court clearly lost its way, and in granting permanent custody of the child in this case, that it created a manifest miscarriage of justice. Mother can't do either. And that's because there's really no dispute that, first of all, that this child was in CSB's temporary custody 12 out of 22 months. That's the first tier of 2150-1414B. And then we have the best interest of the child consideration under the 414D and those non-exclusive factors. And for each one of those factors, we either have no dispute that the factor is satisfied, or we have substantial, clear and convincing evidence to show that to support the trial court's decision to grant permanent custody of this child. And unless the court has questions on this, CSB then would rely on the briefs and again urge this court to affirm the decision. Thank you very much.
You want to rebuttal?
Thank you very much.
All right, thank you. The court will take the matter under advisement and issue a written opinion, which will be sent to both sides, as well as we release it on our website, which is the Supreme Court website too. Thank you very much for your presentations to the court.